I'm talking today to Austin Chessel. Austin is a family mediator at FAMIA and a family solicitor at Shotlands Attorneys in the UK. Hi, Austin. How are you?
I'm good, thanks.
Thank you so much for agreeing to be interviewed by Askimo for our International Library of Online Experts. Today we are talking about mediation versus litigation. So let's start off with, how does choosing mediation over litigation help the children?
Okay, when the parties come to mediation, it's all about reaching a compromise agreement about where the children will typically live or how contact time will work. If the parties go to court, it can be very positional, so there isn't that compromise factor that you tend to see in mediation. So from that perspective, generally how I would see the benefits of mediating rather than litigating children issues. You can also have the involvement of the children in mediation if they're old enough to help shape the decisions of where the children should live and how contact should work.
What age could a child be where you would allow them to get involved in the process?
Each case is different because children develop at different levels, but generally, I guess the youngest child involved would be around 11 or 12, and both parents would need to consent for the children to be involved in the mediation process.
Are there any situations where litigation is preferred over divorce mediation?
Mediation isn't right for every case. Sometimes one party may not want to compromise, so it may be that they have to go to court. If there's been a recent domestic violence, again, the order that they're seeking may be best obtained in the court. And if the child is really at risk and an urgent order is needed, again, it may be that court is preferable in that situation to mediation.
Is divorce mediation binding?
Could you repeat the question?
Is divorce mediation binding?
Okay. The mediation itself isn't binding, but at the end of the process, the mediator will prepare a document called a Memorandum of Understanding, which summarises what's been agreed. The finances have also been addressed. There'll be a financial summary which lists all the assets and liabilities. But that agreement would then need to be taken to a solicitor, who could then prepare a consent order, which both parties would then sign, and then it would be sent to court to be stamped. At that stage, the mediation agreement would become binding.
And who would prepare the final separation agreement?
Well, that would be the solicitor who would translate the Memorandum of Understanding into a consent order.
Who is responsible for beginning the legal divorce process?
Okay, there's various options. A lot of couples who divorce, they can prepare the papers themselves. But if they instruct the solicitor and they want the solicitor to control the process, the solicitor will be preparing the papers for the petitioner. And generally, it takes 4 to 6 months from start to finish if both parties are in agreement.
Thank you, Austin. Thank you so much for talking to me today.
Thank you.